Hi, I'm Richard Pennington. I was formerly General Counsel to NASPO Value Point, now retired, and I'm still a member of NIGP. The short video that you're going to see now assumes that you're either in an NIGP course with an instructor or have completed legal aspects in public procurement, where you've covered invitations for bids, IFBs, sometimes also called ITBs, invitations to bid, or in Canada, invitations to tender. IFBs are used widely, but we're going to discuss today the other major type of solicitation. I'll use the term request for proposals, RFPs, although they're known by other terms also. Request for responses, invitations to negotiate, ITNs, for example. RFPs are becoming more widely used as requirements grow in complexity. And they have their own set of legal issues. I'm going to turn off the talking head video here for a minute so we can dive down into some graphical presentations of some of the differences. And there are differences. There are things in common, but you need to understand, at least from a legal perspective, where the differences lie. For example, in IFBs, there's a public bid opening. That provides an opportunity for competing bidders to inspect the prices and the bids. The issues of responsiveness often are discovered at bid opening and account for many protests. In RFPs, laws and practices vary with respect to disclosing the identity of offerors. Some jurisdictions, for example, have a public opening and announce names of offers. But almost universally, proposal prices and contents are not publicly disclosed until after award. In RFPs, the policies of responsiveness may be slightly different because the process often permits later proposal revisions. The responsive or not article in American City and County describes two different approaches. Some agencies apply traditional sealed bidding law, rejecting proposals with any material informational deficiency. In Pennsylvania, on the other hand, the typical responsiveness rule has not been applied in RFPs. In a case called Language Line Services, the protester Language Line, who lost the award, alleged, among other things, that the awardee was non-responsive. It failed to identify its customer service personnel and their required experience, as the RFP had instructed. The court, however, upheld the award and stated there were only two mandatory responsiveness requirements in the RFP at issue: timeliness of receipt and proper signature. States following this more liberal approach may use the term technical acceptability as the standard. That is, whether the proposal as submitted can be meaningfully evaluated as is, or would require a major proposal rewrite. There are other key differences. As in IFBs, RFPs have terms and conditions that are incorporated as part of the contract, with one addition. In an RFP, the proposal usually becomes part of the contract also. So the order of precedence clause that you've talked about becomes especially important to resolve occasional conflicts in language between the proposal and the rest of the contract. Perhaps the most significant difference, though, is the opportunity for communication between a public entity and offerors about weaknesses in proposals. In IFBs, the only communications with bidders normally involve clarifications of minor informalities, and perhaps communications prior to award about a potential awardee's responsibility. In RFPs, the agency can make a competitive range exclusion or a short list, keeping only those proposals reasonably susceptible of being selected for award for purpose of discussions and possibly proposal revisions before award. In my experience as a bid protest attorney, I looked carefully at the procurement file to make sure that my client was treated fairly, had the same general scope of communications opportunity as that used with the other competing offerors. I also looked to see if my client had an equal opportunity for proposal revisions, if they were permitted at all. Sometimes those are called BAFOs, best and final offers. Another significant difference is the basis for award. As you know, in IFBs, the award is based solely on price and price-related factors, a much narrower basis for award than RFPs. Their evaluation committees consider not just cost, but also technical aspects of the proposal and the past experience of the offeror in what is known as a best value evaluation. Talk to your legal counsel about these topics. Why? Because laws vary. For example, some RFP processes are more like professional services or architect engineer selections where price or cost is not even considered until during the negotiations with the one offeror that is considered most qualified. Evaluation is a special area of interest for suppliers. When I was retained to help a client look at a procurement file, I wanted to make sure that the file told a story of rational evaluation. These scores here were evaluation scores seen by me and my client reviewing a procurement file together in the agency's conference room after the client had been notified it wasn't successful. You can guess from the scores what the concerns were. The experience requirements were rather specific. Yet there were no notes to explain the apparent inconsistency. One evaluator rated a 5, outstanding, and another rated as if references weren't even submitted. The client called the references, found out none had been contacted. The client protested. The agency denied the protest. The appellate authority, a senior procurement executive, sustained the appeal and ordered reevaluation, a not uncommon remedy. What happened? We lost again. There's a lesson here. Those of you whose courts exercise jurisdiction over bid protests, and not all courts do, this slide illustrates the reluctance of judges to overturn procurement official decisions. In short, judges don't want to be purchasing agents, but you need to make their life easy. Document key decisions in ways that people can read and understand. Be on the lookout for evaluation comments that are intemperate or for other documents that just don't seem to make sense. Well, there it is. The key, in my experience, legal issues in RFPs. RFPs are especially valuable when communication is necessary for the agency to understand a proposal, but maybe equally important to make sure that the supplier or the offeror understands the requirements. Further, opportunities for proposal revisions sometimes lead to lower prices. I'm firmly convinced that even though resources are hit when RFPs are used, they are more resource intensive. The communication exchange that can happen, really in my judgment, far outweighs any risk from bid protests.